Welcome to the 60-Minute Clinic, and it's hello from me, Ursula Rice, and it's...
Hello from me, George Sayers.
And we're both solicitors, and we run this clinic every week, pretty much, unless we've flaked out because we've been in court or something, but really quite regularly, which doesn't feel like the best sales pitch ever, but really quite regularly, and it's free, in order to help people who are struggling because they cannot access legal advice because it's very spenny. Good legal advice, cheap legal advice can be terrible, although ours is not. And also, it's not really legal advice, is it? It's help, assistance, signposting, and our best guess at what you're telling us. And some people have found it very, very helpful. So we have already got some questions, George, haven't we?
Yes, we've already got a queue of people, which is good.
Yeah, it's good. So you pick one, let's go.
Okay, let's do, so the first one on my list, okay, it's quite a long one. So this person might need a code name.
I was going with poets. So how about Larkin?
Okay, yeah, good one. Larkin is, that's just changed it to parking.
I mean, it feels very apt. They fuck you up, your mum and dad.
Yeah, Larkin is your code name. Answering now. So Larkin says, thanks for confirming a code name will be used. For privacy, background and context kept to minimal, but can be provided if needed. I have tried to make questions detailed but non-identifiable. History of domestic abuse and CCB, coercive and controlling behaviour. So question 1, where a child arrangements order was made when children were very young, baby/toddler, and has been followed for many years with issues but no return to court, how should a parent appropriately respond when the child, age 12, consistently expresses to them and school/GP that aspects of the current schedule are negatively affecting their emotional well-being, schooling, peer relationships, and day-to-day functioning, including source of suicidal ideation? The child is asking to reduce or adapt contact arrangements. The resident parent feels the existing order is outdated but is being relied upon very rigidly, and there is little flexibility to adapt arrangements as the children have matured. What is considered the safest and most child-focused way to suggest and trial changes or seek variation of the order without risking allegations of parental alienation, reopening of court proceedings, and risking family court making situation worse, or child's wishes being dismissed by child services as parental conflict? I found professionals dismissive and rarely able to accept or distinguish between a developmentally older child expressing their authentic wishes and feelings as a direct response to their lived experiences through the child arrangements order and established relationship with parents, versus assumptions that their views have been influenced when a parent who has experienced a naively reported history of domestic abuse. I am trying to explore how professionally and legally the complexity caused by long-term post-separation abuse can be approached to avoid minimizing the child who is suffering and asking for help. And then it does carry on. Question 2, outside of formal court proceedings, can a 12-year-old child access any form of independent legal representation, advocacy, therapeutic support, or child-inclusive mediation support separate from both parents in order to safely express their wishes and feelings regarding living/contact arrangements? In situations where there are concerns about, so question 3, in situations where there are concerns about an older child's voice becoming lost to family dynamics, what neutral mechanisms are available to help ensure the child's voice is heard independently and safely without either parent later alleging coaching, influence, or parental alienation, and courts being weaponized using the same allegations? Question 4, can a child access legal aid or be covered through parents' eligibility to cover any child inclusive mediation costs, or if they want independent legal advice and advocacy? Oh, well, I think it would not be expected for an order that was made in the best interests of a baby/toddler to still be in their best interests when they are age 12. And I think every family court decision is made in the expectation that the order they make at the moment is not going to stay their whole childhood, because children evolve, things change. What's right for them when they're super young is not right for them when they're definitely 12. When they're getting to that age of, they're not, obviously you're not in any way independent when you're 12, but you're more independent than you were than when you were 2.
And you have your own idea of what you want to do. You've got more autonomy. You don't just do what your mum and dad say. You've got your mates you want to start traveling about with.
Yeah. So it's 100% a welfare concern. If this child is saying, I'm really distressed by this contact I'm having with my other parents and I want things to change, when it should be, you should be able to say to both of your parents that you're having contact with, that a court deemed safe years and years ago, to say, look, what we're doing here is, I'm really struggling under this. So I think, as we said earlier, it's obviously very difficult in some instances to give someone a full overview of what they should do over a Facebook Live, because obviously there are some real big issues happening with you, Larkin, and little Larkin. I think, Dad or other parent sounds like someone who is not being child focused in any way. It should not be something you're fearing to say, I'm worried about allegations of parental alienation or coaching, etc., when you've got a child that's saying, I'm really distressed at all of this, and mentioning suicidal ideation. That's
not normal.
Yeah.
That is not indicative of a happy relationship between the child and the other parent. And the fact that you've managed to carry on with this order for more than 10 years, or about 10 years, without going back to court, says that you yourself have been able to navigate the challenges and keep A, contact going, so therefore containing your own emotions, and B, you at least are not conflictual. It might mean, of course, that you have very low boundaries and that in fact you've been too soft about things. That's possible, and that's not a criticism, by the way, but what nobody can chuck at you is alienation. How can it be alienation? You've kept this going for more than 10 years. How can it be alienation? So I think you're quite strong on that.
Yeah,
I always take the view that once a child is expressing serious emotional anxiety, including self-harming thoughts, that you can't just pretend that's not happening. I think it's at that point it's time to go, this is happening, and I have a duty to protect. So I take quite a hard view on things. My advice is often call it, say, I'm not going to facilitate this harm anymore. I get quite tough about it. And I think in the appropriate situation with the correct track record, which I am feeling that you have. So
yeah, nothing about what you've said, Larkin, would make me think that something like child inclusive mediation would make other parents sort of sit up and think, oh, maybe I haven't been doing the best thing. Like maybe it's me. Maybe accusing everyone of being in the wrong and me being perfect isn't actually the best idea. So I can see maybe, the exam question answer is probably child inclusive mediation is what you need to do. I bet Kafkas would probably say that. But in reality, mediation is voluntary. No one is going to be there saying, Dad, you're the problem. And certainly Dad isn't going to be thinking, yes, I'm the problem from what you've said. I think also, statistically speaking, 12 is absolutely the age in which the family court do start considering that children are able to articulate their wishes and feelings independently. And I think, yeah, you could have, I mean, you'd need to be kind of brave about it. But if you said, look, I'm not going to facilitate this. If you want to take me to court about it, be my guest. But I no longer think that, I think you're actively causing harm to our child, and I am stepping in to safeguard them. And I do your worst, and I will turn up to court if you make an application. But I would think at that age, you certainly have a strong argument to say, this is what's happening. This has been the effect on their mental health. This is what they're telling me, what they're telling the school. And I think their wishes and feelings should be respected.
Yeah, I think you could also think about looking for a family therapist as well. But you started off by saying that there was domestic abuse and coercive and controlling behaviour. And what I'm reading between the lines, and one of the things I think that's happening is because if you yourself have come away from being able to be the victim in that, basically the child is now the controllable person. And that's actually what's happening here. And that's a very common pattern. Coercive people don't get divorced and go, oh yeah, no, definitely my bad. I'm definitely going to get some insight and maybe do some work. They don't. They're like, I was right as per. And they just carry on dynamicking the way they dynamic. You know, that's how they roll unless they do the work. And the nature of coercive control is generally that they don't do the work. So I think I echo what George says. I think you're going to have to be brave, and it's time to protect your child. And I do agree that child inclusive mediation is probably the child focused way to go about this. But and family therapy could be another way. But what it isn't is, and we will carry on doing this order while we do this, because something has to change. That's the outcome of this. Something's got to change. And dad's got to change is fundamentally what the issue is here. You asked as well, professionals being dismissive. I'd say this, yes, but that was 10 years ago, and I think a lot has changed, including the guidance on alienation, including the Domestic Abuse Act coming in, and including the Practice Direction 12J, I'm pretty sure falls within 10 years, as does a huge amount of training for the judiciary and CAFCAS. So I'm not sure child conflict is what they would hear. You asked whether the child could get sort of their own independent legal representation. I would say not. The only at 12, I wouldn't expect them to automatically be represented by a children's guardian. And there aren't, neutral mechanisms. I don't think there's no neutral mechanism, because neutral mechanisms assume that everybody's in good faith. And I don't think one of the people here is in good faith. Yeah, I think it's all about you and your potential legal aid, not the child's legal aid. So I hope that helps. Okay, let's go on to the next one. So this is a new viewer, and we have given the new viewer the code name of Shakespeare. So doing you now. Hi, says Shakespeare. Could I request a question for the live tonight, please? I'm the primary carer for 2 children. Child maintenance has recently reduced significantly. We were divorced last year, but no financial order has been made, as attempts to resolve financial matters by agreement have not been successful. I'm currently unemployed due to ill health. One child is neurodivergent with significant school attendance difficulties, which affects my ability to return to work and increase my income. The other parent has a substantially higher income than me, but says they have significant debts incurred after our separation. I am concerned about maintaining a stable home for the children long term. What financial options should I be exploring beyond child maintenance, and how can I assess whether a financial remedy application is worth pursuing before full financial disclosure has taken place? So Shakespeare, I definitely would say that a mediation I would recommend a start at mediation. I think this is a conversation which seems to me to need to be had with a third party, because if you've tried to get a financial order, then unless you've already tried mediation, in which case, okay, so step 1, try mediation. Step 2, I think you might want to say, well, we all don't want to go to court. We're really clear about that. I'm assuming that's the position. We all don't want to go to court. And the answer is in here somewhere. Let's all do proper disclosure as if we were in court, so on Form E, and then go and see either somebody who offers the single solicitor service, as we do, or perhaps hire a senior barrister who specialises in finance to give you both what's called an early neutral evaluation. And if you were to do that, I would certainly recommend somebody who also sits as a family court judge. So a lot of barristers sit part-time as family court judges, and that is, you need somebody who's used to making decisions and being, specific. So yeah, I would say that the alternatives to court, if it's not mediation, would either be the single solicitor service, which we do, by the way, or go and find somebody for some early neutral evaluation, which we also do, by the way. And there's actually, I'm going to put it in the comments, there's a good link to our website about all our alternative dispute resolution things. But there's more than one way to skin a cat, I would say here. But you've got to have disclosure. I mean, don't get too pernickety, but your basic full disclosure is important. If you don't have disclosure, you don't know what you're arguing over, do you? And these are important decisions, and you have a significant factor with a child who's so neurodivergent that school is iffy, which takes you out of the workplace, I would say. So, course is not my first go-to because of the expense. People have to be extremely. The court is the places where you want to be in court is because the other side is so barn pot mad that you can't get a grain of sense out of them. You're just going to need a grown-up. You need somebody who's got authority, who has power. Point 2, if the assets are complicated and quite large, then it can really be worth fighting over it. It literally will mean the difference between eating baked beans forever when you retire and not eating baked beans forever. But there is a lot of middle stages where even if one of you is losing out on what you feel is fair, like say 75 grand, you could spend 75 grand easily between you from the assets, effectively fighting over it. So that's at which point one of you might as well have the money because it will go to the kids eventually. So I do think there's a calculation to be done about whether it's worth it, and cost benefit ratio is really important. And if anybody out there has got solicitors who are not thinking, is it worth it, and being quite aggressive with their thoughts about that, then you should be really thoughtful about whether you're instructing somebody sensible, I would say. Because I think that's one of the things that a lot of lawyers, they don't think about enough. Is it worth it?
Completely agree. Yeah. And that's certainly not something that ChatGPT is going to tell you either. It's about doing that calculation as to whether it really is worth it.
Yeah.
Which is also an issue. Yeah.
So there you go. That's that. I hope that helps. On to the next one, George.
Yep. Let us do
starring people like Billy-O.
Yeah. Okay, let's do this one. So answering now. This one is Lampshade.
Some code names really are epic. Terrible.
Hi, I was Lampshade last week. Love the names you come up with. My husband and I were together for 13 years, 10 married, separated almost 2 kids together, 10 and 13. And I have 4 older kids who are adults. He's becoming increasingly hostile and generally being really horrible towards me in messages. All I've asked for is consistency with our kids, child maintenance, and for him to stop using my address. Child maintenance have failed to get us a penny for over a year, and I just put in an appeal/tribunal thing, and child maintenance did the annual review and said he now has to pay. He still isn't paying. I've requested the 20% minus 4%. He's trying everything to not pay a penny. He's now making a civil claim for fraud for giving his girlfriend's address expenses as he has to keep downing tools to sort my shit out. He's this week received the child maintenance tribunal papers, and he's now told the kids he can't afford to see them as I'm taking him to court and taking all his money. He's self-employed, no domestic violence. I'm on universal credit and PIP for health issues, and I'm being told I'm delusional, worst person ever, ruined his life, stopping him being able to see the kids. He moved 2 hours away. Is there any help on moving forward with this, as it's affecting me and the kids emotionally and financially? Lampshade, I'm really intrigued with you sort of specifically saying there's been no domestic violence, because everything you have described is a man who is perpetrating very serious, not regular behavior abuse in a big way, and just
emotional and psychological.
Just because it's not physical does not mean that it is not very, very serious, and is probably affecting you even in a way even worse than what you're realizing at the moment.
Yeah.
And I think a first port of call is for you to access some help with that, such as the Freedom Program. I think you should start there, the online Freedom Program, which costs 12 quid, I think.
Last time I looked, it's buttons.
Yeah. And it seriously is worth doing, because I think what you need to start with is understanding his behavior and what it's doing to you, and also probably what it's doing to the children. Obviously, when relationships break down, even with the most non-toxic, pleasant people, there are arguments, there's, bad words said, and there's shouting. But what you're describing goes way further than that. It is not okay to be including the children, for example, in the reasons for the breakup, and for him to be blaming you for it, telling them about the money troubles and all of that stuff, saying that you're being horrible, etc. That is not normal behavior, and it's not child focused, and no one would ever say it's justified.
Agreed.
So I think that's really what the perspective shift you need to move to is to realize that he is being a dickhead, in all honesty.
Yeah, 100% agree with that.
I mean, we were just sort of saying as well in the previous answer to the question about how court really should be your last port of call. And honestly, I don't think you're far away from that. If he's not paying child maintenance and doing all he can to avoid it, then that is just boosting up your needs at the end of the day. And because you've been married, that is one of the factors that the court takes into account, is needs. And that is prioritized, especially the children's needs, beyond everything else. And I think you need to think about saying, look, I think we cannot trust this guy to actually pay the percentage of his income that the child maintenance has said. I actually do need some further assets, or I need to have a greater share of the pot, because obviously it's going to be falling to me to actually bring up these children.
Yeah, agreed.
I also think you could probably do with laying some boundaries. Again, this is the sort of thing that the Freedom Program could help you with. With his messaging, I don't think you need to stand for it. I think you would be absolutely justified to say, I'm blocking you on all channels. I am willing, you could say, I'm willing to try mediation, but this kind of behavior has to stop, and I'm only going to do one session if it's clearly not going to go anywhere. And if you have a sensible mediator, then I'm not saying that it's going to be impossible, but I think you've got a real troublemaker on the other side, and I think you should definitely be prepared to having to get this into a forum where someone's going to have to make some decisions.
Yeah, and you could get you might if you're on universal credit, you will get help with mediation. You'll get at least the 500 quid voucher, plus you might get legal aid for it as well. And you know, don't hesitate to use this. I mean, if you're on universal credit, I'm not silly. We know that what I've got on the banner at the bottom here that says, you know, first interview is 180 quid. I know you can't afford that if you're on universal credit. So use our clinic, you know, use our clinic once you've got some more information, or maybe save up to do 180. So if you want any legal advice, but just like really try and avoid putting your hand in your pocket if you can. You know, there's the other thing you might want to look at is something called Advice Now. Advice Now have some really good resources. Oh, hang on a minute. What have I done there? There we go. Yeah, they've got some fantastic resources that are tailored. In, you know, a lot of people come to us saying, I've been to the CAB, but they weren't any good. They just said, oh, here's the government website, which just, you need tailored advice. And I would say Advice Now have got a better pack of resources than the more generic services. So I really echo what George says. I think your state of mind is heavily, heavily influenced by the fact that you perhaps haven't described this historically as abusive behaviour. I think it's extremely abusive. I think it's psychological and emotional abuse. That is as defined in the Domestic Abuse Act 2021. So even the law says so. So there. And it's economic. It's clearly economic abuse. I mean, it's just textbook economic abuse. So, yeah, it's not cool.
Isn't it absolutely insane that when a parent, when a non-resident parent is not paying child maintenance, that you can claim universal credit, and yet there isn't the kind of joined up thinking of maybe the universal credit people should grow some teeth for the people that don't pay child maintenance.
And just like, maybe increase their tax by 5%. Yeah. How about that? You know, how about that? Like Rachel Reeves wants to, you know, Labour generally wish to improve the lot of children in poverty. One of the greatest steps they could do was grow a pair of balls for the CMS, but also HMRC. If that was joined up, HMRC could just say, well, you're self-employed. You now are required to pay an extra 3% across the totality of your income in order to so that we can divert some extra universal credit rather than the CMS. Why not get HMRC just to add a couple of percent to people's tax returns? That would pinch a few people, wouldn't it? That would be quicker, actually, because you could also, I mean, they effectively have an agency which could collect some money.
Yeah. For any MPs that might be watching, this is something you should do.
Yeah, any MPs that are watching, this would be a vote winner, whoever you are, whatever your stripe. How about finding out about the absolute inbuilt sexism of what happens when, as a general rule, men do not wish to pay for their children? It's the go-to calling card. I'm calling it. It's blokes. There's a sort of subset of man, isn't there, who just thinks, meh, not my problem. And also, how dare you trouble me with this annoying pestiferousness and interfering with my ability to go to Nando's as and when I wish. Losers. Yeah,
one thing about this job is you are constantly shocked at the lengths people go to not to pay for their children. Is quite a revelation.
It is a revelation, isn't it? And you kind of can't quite believe that person let that thought outside of their head.
Yeah, I know.
Yeah, wild, absolutely wild. Anyway, have a little rant. Next is okay. Right, what are we going on here? Basmati, let's do you. Right, Basmati. Is that right? Yes, Basmati. Hi both. My hearing is next week to see if the fact find should go ahead in child arrangements. If the judge decides it's not worth it, apart from a Section 7, is there anything else I need to remember to make sure is included in my next interim order? Or do you have any suggestions I can put forward on what I should ask for? Do they suggest co-parenting courses, etc., or something that helps us? Also, contact is still via a third party. I'm scared the judge removes this. Would he remove this if he feels a fact find shouldn't go ahead, or will he wait for Section 7 results? Thanks. Basmati. George, is Basmati a bit of your client?
Yes, I think so. Yes, you are, but only on the money side, not on the
Right.
children side. Yeah.
So it seems to me, because he was on bail for harassment.
Yeah, I think the bail conditions were dropped and the police have NFA'd it, as they do.
As per.
Yeah.
It's hang on a minute. Okay, well, I don't know enough about your situation to figure out what the judge will do, but what you're asking is what happens if it's a no. Well, the first thing is I think it's perfectly okay to say, I understand you might not want to do this on a separate fact find basis, Judge, but just FYI, I don't renege from what happened, and I think you might need to make some findings, but in what's called a rolled up hearing, where the judge makes the decision on welfare as well as the decision on facts if needed. Sorry, I've got jellies. Behold.
Oh, yummy.
Yeah, lawyer crack. And so good. So if you think it's relevant, you could ask for police disclosure, couldn't you?
Yeah.
If you think it's going to be relevant in a rolled up hearing, you would maybe ask for police disclosure because you've had police involvement. Obviously there'll be statements requested.
I think because Basmati is represented by legal aid, I'm assuming you still are represented, Basmati. I think really, I mean, your counsel will need to persuade the judge is that a fact-finding hearing is necessary and proportionate. So we hope that the allegations are laid out very clearly and are very much connected to the welfare of the child and why it matters, why a judge needs to decide whether something happened or not for there to be, for the court to set aside that time to have, a 1 day, 2 day, 3 day hearing, whatever it's going to be. But I think, I think certainly it would be correct for your barrister to sort of say, look, whether or not you order a fact find today, Basmati is not reneging on the allegation she's made. They very much continue to be the factual matrix from her point of view. So either we have one now, or probably the Cafcass officer in their Section 7 report is going to say, Mum has said all of this to me about what Dad's done. Yeah. And I can't determine whether or not that happened because that's not my job. And then probably will necessitate needing to have a fact find rolled up in a final hearing or still have one after the Section 7 anyway.
Because sometimes Cafcass go do an either or. If what Mum says is true, then this would be my advice. If not, then this would be my advice. That's something that the Cafcass officers should be directed to. They should be told to think in that way. In a what if this, what if that, because otherwise they forget because they're busy. I know. Yes, they should do better, but just like spoon feeding people, it's the lawyer's job to do the thinking, isn't it?
Yeah. But the fact that the police have NFA'd their investigation should not be like an instruction to the family court to do the same, because Correct. we work on a different standard of proof.
Plus, they have the CPS test to meet, which is it in the public interest, and is there a reasonable prospect of conviction?
Yeah, and I bet you Dad's representatives are going to all day say, oh, well, because the police have NFA'd it, then obviously we don't need to have a fact find, and it's clearly not a pertinent issue. But and I then hope that your barrister would stand up and say, well, they're two different things working on, a different legal a different legal standard. And yes, it is relevant for the family court. Thank you very much. And I mean, we all know, let's face it, the police, I'm not directly criticizing you, police, but you don't perhaps do as well as you could with domestic abuse cases.
It's patchy, isn't it? There's some really outstanding officers and really outstanding practicing officers who understand dynamically what's going on. But that tends to come with experience. And the problem is this is a very subtle beast, and particularly younger officers or younger in their practice and in their authority, you know, how long they've had a warrant, is where the outstandingly crap officering can be. And and it's the luck of the draw, and they're used to dealing with villains, and that's their perspective. So they're not always as in tune with what they're really dealing with, even though it's been made a crime. So yeah, it can be really hard. It can be really hard. So you got police disclosure received last week. Okay, good.
Okay, well, good. That will be worth a good read and seeing what's there.
And as to the third party, I mean, I'm hopeful that a judge wouldn't, if they've made a decision that that's what's needed till a final analysis is done, then that should stay, generally, unless something's changed. If nothing's changed, then that should stay.
In my experience, when a party is saying, I am fearful of this person and I really would want there to be a third party, even when there hasn't been a fact find or when there haven't been findings, I've certainly had final orders where they've said, well, there still needs to be a third party, if that's what mum or whoever is saying. So I wouldn't think just because a judge is saying, no, it's not necessary to have a fact find, they would say it's also not necessary to have a third party.
Yeah. All right. Well, I hope that helps. Thank you, Bhavana. She says I look nice in blue.
Oh. What about me in green?
Yeah, loser. Okay. Do you want to pick another one?
Yes. Shall we do this one? Cavapoo, this is. Still.
When we were talking. No, that doesn't sound right. When we were doing it. So that doesn't sound right, but yes.
We were doing breeds of dogs as a code name. Yeah. So Cavapoo says, it's me again. After CAFCAS Section 7 to progress contact with dad, 12-year-old refused. Contact centre made notes. Now ICFA has been ordered. I was asked to choose between legal guardian or ICFA. I chose ICFA only for the reason that I didn't want to stress child with more frequent consultations. Please, can you advise what's the difference between ICFA and legal guardian? What will ICFA do? There are allegations of me influencing child with my narrative, parental alienation. In reality, dad abandoned us both 3 years ago, returned to claim custody. Yeah, I mean, I think I'm sort of surprised that someone sort of gave you an ultimatum to say it's either ICFA or
either or.
Yeah.
You choose.
Yeah, I don't think, though, ICFA is a bad place to go at all. I mean, essentially, how would you describe it? I actually cannot even remember what it stands for.
Neither could I. Something like intervention. I can't remember what it stands for. But what it is it's usually an accredited contact centre, isn't it? With a very with some quite strict tramlines as to how they reintroduce contact, which includes, it's a program of reintroduction. So it includes a first visit for you and the child, a first visit for dad, all separate. Not that the child would be with you on at least all of those occasions, but dad sees it separately. You would probably see it separately. It includes a visit where dad doesn't actually turn up, but they're talking to the ICFA worker. It's quite careful handling. It's not just like at any old contact centre where everybody just bimbles in and plays with toys for 2 hours. It's with very specific it's with some social work around it, basically, and they can work. They can work. But complicated dynamics, does just being everybody being nice work? I'm not sure that it does.
But crucially as well, there is a report done at the end of it, and
This
where they say, look, this is what we've tried, this is what child has continued to say to us or not continued to say to us, and
this is how it went.
This is what we think is the issue and whether it should continue or not. So yeah, it isn't just a question of child and parent thrown in a room together and locked in for them to have their hour of contact. It's a much more considered step-by-step process in which it's intended for the professionals to really see what the issues are.
Yeah.
So if you're having parental alienation shouted at you and the report at the end of ICFA says, actually, it is dad that's the issue and child is, terrified of him, then, that's obviously going to show up dad in quite a big way. So yeah, I think probably I can see why you would have chosen ICFA over there being a guardian appointed.
Yeah.
And I don't think you've made a bad decision about that.
No, agreed.
And, I think just let us know.
Yeah. Tiger agrees.
Yeah.
Tiger says.
What do you say? What do you say? You're just like on a low-level whinge.
Yeah.
She's like farting and she's farting and whinging. Yeah.
Oh.
Poo. Anyway, small break to say welcome to new viewers, because I know we've got quite a few, and that is lovely. So thank you and hello. And yeah, we do this every week, so for good or for bad, you have to listen to us waffling on. And what else was I going to say? Obviously, also hello to all the people who are watching back, because that's nice as well. We really like to see the comments as they come in, so thank you for commenting. By the way, apparently you look nice in green, George, so
okay, thank you.
It's all fair. It's all been very fair, I would say. And finally, as well, if anybody feels they've been super duper helped and wants to talk about or share or like the page or share it into groups, we would very much welcome that. That really works for us. We know that a lot of people find us through various like divorce groups. So if that's something you could do, that would be brilliant. And also to say that the next 60-minute clinic will be on the 11th of June. So we still have 50 minutes of this one. But yes, once a week we are here pestering people. So yes. Okay. Our next question then is this. Let's find out who this person was. This is Martini. So Martini, doing you now. Right, Martini. Hello, me again. I'm not sure if I'm entitled to legal aid now. Oh. Apparently, I received emergency legal aid for my first hearing last week, and the judge ordered no interim contact, police disclosure, and a fact find. That sounds like a result, Martini. He ordered for us both to pay for half of the police disclosure. Now, obviously, I was under the assumption I'd have legal aid. Now, if they don't grant me, what do I do? How do I contact the judge to let him know if this happens? I can't afford to pay for half, as it's about £300 each. What shall I do to prepare myself? Okay. If, oh, okay. If you don't get legal aid, what you would be entitled to is something called help with fees. And help with fees means you could make a court application, which at least you don't have to pay to make the application. if that was the case, you could apply for an order about the fees, saying there's a change of circumstances, and it's my position that I shouldn't have to pay for half of police disclosure because I can't. And it depends what court you're in. I mean, for example, if you're in the Bristol Brighton area, that will just go into a black hole somewhere and it will just never really see the light of day. And you might as well just wait for the next hearing to go, well, we haven't got the police disclosure because I've got no money and I'm not legally aided anymore. So that's one thing you could do. But why that is not ideal is because that will delay matters. Because if you've got a fact finding, police disclosure is clearly important extraneous evidence. And it might make people wonder whether you're deliberately delaying. Alternatively, you could think about writing to your ex, reminding myself you're a victim of domestic abuse. Does that feel like fun? No. But saying, please, in order to get the police disclosure, I can't afford it. If you pay, you could ask the judge to decide whether I have to pay my half, but I just can't pay to get it. And not having it delays what you want, which is the decision, for more time. You could do that. You could write to him and say, you pay, and then we'll argue about whether I have to pay my half. And then at least we've got it and we can have the argument. I think I might do that. And the other option is you find 300 quid somehow, which I realise is really difficult. That's sort of what I might think about doing. What about you, George? Any thoughts?
Yeah, I think that is a dilemma. I mean, I think you'd maybe want to try a number of those things, wouldn't you? If you do qualify for help with fees and you don't have to pay a court fee to file a C2 application, why not do that? I mean, it may get lost in the black hole of court administration, but at least you can then say it's not because I'm trying to avoid it. I have actually made an application. If you get to the next hearing and no one's done anything about it, saying I have told the court that this is my situation. But also having the police disclosure is very important for you as well, because it could also be the evidence you need to get your legal aid back. I think that's
there's been a comment within the DMs, which is for police disclosure, couldn't a free subject access request be used? I completely see why that seems really clever to avoid, but it will be so heavily redacted that it won't really work. What you want is the unredacted, everybody's names where they should be version, and you can only get that with a disclosure order from the court. So, hey, here's a clever idea. Get someone to help you do a GoFundMe page. You could raise 300 quid easily. That's a really clever idea. Go Bhavana. I love that idea. Yeah, 100%. What about that? That's a great idea. Little GoFundMe, $5 here, $5 there. You could raise the small amounts needed. That would be excellent.
Make sure you are, though, within the bounds of confidentiality and the rest of it, though. Don't mention names and things like that.
No, exactly. Oh, bless you. The reason for legal aid is too much capital, not domestic abuse, and we have a non-mol in place. And maybe you're not even going to get like sort of tiered legal aid. Like you've got to pay a contribution. Oh, that's awful. What I thought they had a capital disregard. Where it used to be, and I know this is 20 years ago when I was doing it, it used to be that was never counted because that was the subject matter of the dispute, and everybody knows you can't just go, oh yeah, can I just take a few bricks please down to the bank and turn them into money?
Yeah.
Fume. Oh, that's okay, Steph. I'm glad that we're able to help, because people are really struggling, aren't they? They really, really are struggling. No two ways about it. We've helped some people over months, months and months and months. And yes, you can ask more than one question. We don't get to everything all of the time, but we do our best. And we have some people who sort of travel, their whole kind of case travels. We travel with it just to chip in as much as we can. I mean, it's not always, we do our best. I think that's all we can say, really. So yeah, okay, too much capital. I mean, okay, and what's more, what I really suspect, Martini, is that capital, every single brick and piece of mortar is completely important to you, and also you're going to need to keep your credit up. What I will say is, if your legal aid lawyer was not very good but free, you shouldn't hesitate to switch. If you're because they sometimes you get assigned very junior people when you're doing legal aid, and that is often the main problem with legal aid, is the quality, because the junior people mean really well, but they just haven't got the miles on the clock. And they're also massively overloaded. I mean, the deal with legal aid is they'll pay you a third of what you're worth, but you can have more work than you can shake your shitty stick at. So it's really difficult. So it gets overloaded so that the firm makes a profit. It's got some very inherent unsatisfactory aspects to the funding of legal aid, and it's had a real bearing on quality. And that's not to say all legal aid lawyers are rubbish, but they can be patchy. Somebody's asked how to do a question. If you want to ask a question, you need to like the page, and then you private message us your question, and we will give you a code name, and we'll use the code name to tell what the question is and answer it. So that way your privacy is protected. Yeah, what I think the GoFundMe idea was actually a really good one. And yeah, be very careful about confidentiality. You can't go blabbing, because the family court come down really hard on that. So
Yeah.
okay, so they're trying to argue that it's trapped capital. Well, yeah, it is, but you've not heard back yet, and your next hearing is in July. I think all you can do, Martini, is possess your soul in patience and hope for the best. If they're arguing it, they must think they've got a shout, and obviously you have need. So yeah, good luck. Keep us posted, please.
Can we do this next one?
Yeah.
This is Viva La Vida.
Oh yeah.
Who says, final hearing in Feb 26. After countless applications to courts from Dad, I managed to get a barring order and to continue to use parenting app to communicate. Dad didn't get all the outcomes he wanted. He is now refusing to use the parenting app and will message via our daughter. What do I do? Malicious communication and countless restraining orders. Second, want to freely allow communication other than the app, but he keeps bringing our daughter into arrangements. I wouldn't mind knowing what the age of daughter is, just to have it
and how she feels about it.
Yeah, but I think you have an order that sounds like it's very clear that communication is to happen via a co-parenting app. I think you would be completely justified in blocking him on all other forms of communication apart from that app. I think your daughter would be also justified in doing the same, or you doing it for her if it's sort of an age appropriate thing to do, which it probably is if you've been through the family court. And either what's going to happen is his messages are going to go into the ether that no one is ever going to see because he's blocked, and any contact that he has been allowed is not going to be taken up because you can't arrange it, or he's going to have to start following the order, and he can't make an application back to court anyway. Certainly if he's going to say my mum is following the final order that you made and I'm not, and I think I should get back to court, it's probably not going to reach the threshold for the section 9114. She is 16. Well, goodness me, I have no idea why there is even an order then. She claims he tells her she has to be involved, as I won't allow messaging any other way. Well, I think 16 is not an inappropriate age for you to say, you know what, we've actually been through the family court. I want to lay some boundaries about my communication. The court have agreed with me and said we had to communicate via an app. What do you think? Who do you think is actually telling you the truth? Yeah, I think this is boundary territory.
two 12-year-olds too, caught since they were around 5.
Oh,
Yeah.
okay. God.
I think you're right. I think this is about you taking modeling really good boundaries with everybody, because there's a little bit here which is where you're being used as the punch bag by everybody somehow. Like, he's being shit and it's all your fault, and everybody's allowed to go, yeah. I feel for you, because I think there's going to be, I think this is very bad for you and your mental health. And you need to show what a dignified no thank you looks like, and that you here's what boundaries look like. Like, you can't step over it. This is the rule. And the thing about boundaries is you have to go stuck record over and over and over again. That's the only way that you reinforce them. We have.
I think we've got 2 questions remaining. We've got Dubonnet and Poodle.
Dubonnet, yeah. Shall I just quickly do Dubonnet?
Yeah.
Right, doing you now. So now I have a court date in August, says Dubonnet, for review of the updated Section 7 report after a positive ICFA intervention. Okay. I'm hoping to get to the child arrangements order creation progress after August, but I'm wondering if my ex will be able to insist on a load of restrictions being put in the child arrangements order, as this is what she has done throughout the entire process to stop my relationship with the boys. It sounds silly, but does the child arrangements order have to be fully agreed between both of us? And what happens if there's not an agreement reached? It's not silly. The child arrangements order is either made by a judge who decides what's going in it because you're at a final hearing, or you both have to agree. And I would say that realistically, the more detailed an order is, the more careful you have to be that the detail works for you and not against you. Sometimes detail can be really helpful, because what you might need is a defined order that's very specific about when it's your turn to be with those children. And sometimes you might be like, well, we need to have a bit more flexibility here. But definition often helps, I would say. So it should be quite so specific, because actually the order's against her. It's not against you. It's against her. It's about Mrs. Dubonnet has to make the children available in such and such a manner. So remember, that's the way round that it is. She's subject to the order, not you. And if there's not an agreement, then frankly, you'll be going to court for a final hearing. So that's what will happen. Yeah. So that's that. We're nearly there. We've got 2 more minutes.
Should we do Poodle? So on now, I'm just gonna say on now. Poodle says, I have a child arrangements order with my ex via Family First. He also has parental responsibility. My twins were very preterm and are 7-year-old and lagging behind in school despite catch-up lessons by school. Teachers suspect sensory issues, preterm related dyslexia, dyscalculia, perhaps ADHD in one. They had an educational psychologist in 10 days ago to assess them. I'm still waiting feedback and discussion with teachers. Should I be informing Dad? I'm assuming school informed him. He's going to create chaos with school, so I'm petrified. I have been in touch with teachers in last year or so with one kid's behavioural issues at home with me and nanny and his twin sister, mega tantrums, hitting, throwing stuff, taking ages to get back or to school, as sits in footpath and refuses to move. I did an understanding your child 4-week course at schools, signposting last year. Also, a few months ago, my nanny and I asked GP to make a referral for son to assess for ADHD. Sorry, as I was concerned with behaviour, he's still on the wait list. Should I be telling Dad I made the referral? I was thinking we'll tell him once referral comes through, / with assessment results, etc., as Dad will go berserk, and I don't want to deal with that before any diagnosis, etc. Also, filling for me for FDR now, so I'm mentioning twins being assessed at school. Just want to do the right thing for my kids and be right by the law / court's eyes.
I know this case. I know this case very well. It's really tricky because I know exactly how he is. He's as difficult a man as can be. Mr. Poodle is. Think difficult and then magnify it.
Can I say what I was thinking,
Yeah,
knowing
go on
the
then.
case less, is I
Yeah.
think not concealing it, no. And if it's relevant for a Form E, then you should say it. But I calling it, I don't think you should be actively telling him if you know that it's actually going to, if he's going to kick off in a way that's actually not going to be good for the children's welfare or even your well-being. That would be my feeling.
He'll have to know eventually.
Yeah.
I
But
mean,
it would be better if he knows after it's happened, because
Yeah.
before it's happened and he tries to stop it, then that's surely the worst outcome.
Yeah, I mean, surely doctors and teachers who are advising that this should get going. I mean, because it could be quite some delay before there is an assessment.
Mm.
I suppose I'd be a bit worried about that, like how long it would endure before, like, while this secret is kept.
But he can. Dad can be the one that's asking the school. You know, it's not that he's prevented from knowing this. If he's really interested, then he should be talking to the school about how his kids are doing.
Yeah, exactly. And
So
yeah, exactly. How does he not know?
Yeah, it's not Poodle's fault.
Yeah,
She would say, well, you've had the ability to find all of this out. You know, you've obviously never been interested in their, you know, their progress or anything.
Yeah, yeah.
Also, just as an aside, before an FDR, you don't need to do Form E again if you've already done it. You need to provide updating disclosure. So you don't need to do the form again, but you need to provide.
I know it's for the first appointment. I think it's for the first appointment.
Okay.
Yeah,
Okay.
I think from memory. And I think I'd probably agree with George. I would tell him once the referral actually comes through, wait till you've at least got as far as diagnosis. Because this particular gentleman will also probably lean on his son to say, there's nothing wrong with you, there's nothing wrong with you. He actually probably would. He might sort of skew the results a bit. Don't know if that's possible. I'm not a doctor, but yeah, that's what I'd be worried about. Yeah, maybe just keep it to yourself for a bit. Let's get a little bit down the track before you could maybe inform me, just say, you know, there are concerns that potentially one of our children may have diagnosable mental health condition /
Send.
Special educational needs. Just very quickly to finish off, Vida La Vida also says he's told one of our twins he can't afford to see them like the girls as I take too much money off him in maintenance. Of course he has.
Yeah, that's
and he's refusing. He says everything, doesn't it? He's refusing to pay for the app. Is it worth a solicitor's letter telling him he'll be in breach of the order? I mean, yes, but he seems like a slightly uncontrollable guy. I mean, my go-to would be, well, if you won't pay for the app, you won't be having any information about them, because I won't be talking to you any other way, soldier. Right? So
and fundamentally, us solicitors, we don't have magic powers. We certainly don't have powers to make people respond to us or do stuff.
No.
And it's just sometimes a letter with headed letter does something, but it's not guaranteed.
It's not really, is it? That's the thing. That is the thing. Right. Okay. So everybody, listen, thank you so much for joining in. That's the end of the 60-minute clinic. That means it's jolly well nearly Friday. Hurrah. Nearly the weekend, even hurrah. And thank you so much for joining us, and we'll see you all again next week. Good night from me.
Good night from me. Bye.